The article was republished in Franchise Times recently and entitled "The Giant Has Awoken: Franchisors and the FTC's Crosshairs." Ron, will you share with us the issues that you highlighted and the takeaways from that article?
Sure. That article was originally published in the New York Law Journal. I have the privilege of having a periodic piece in that publication. And I had written an article back in 2018, actually, that said that from where I sat, it felt like franchise agreements had become more and more overreaching, that franchisors were controlling more and more of the day-to-day operations that were happening within the four walls of franchising, and that if franchisors and their lawyers weren't more careful about things, that at some point in time, the government was going to come in and do something to protect franchisees who felt like they were being overmanaged. This article that I wrote in March was essentially a "I told you so" in light of what's happened in the last year or so. I had recounted that the FTC rule, of course, is up for a review. I mentioned the Cortez Masto report from the Senate, which came out in April of 2022. At the time, the GAO study had not yet been released. It came out like 3 days after I wrote my article, but I was aware that the GAO was doing their study of franchising. We had, of course, the FTC request in January about the non-compete issue, which we all thought was going to be the big news when we got here. But then the RFI came out, which suddenly greatly overshadowed the non-compete. And so my point simply was, look, this has been coming for a long time. This reconciliation and overreaching from the view of franchisees is overdue, and I think franchisees have felt helpless in the face of any other solution than government regulation. And the risk with regulation, as in all government actions, is either they don't do enough or they do too much. And so here we are faced with what's going to happen next, and I know everybody in this room, or most people, think it's going to be far too much. I'm not sure I'm ready to say that yet. That will be probably one of the conversations that we have today, but that sort of sets the table for where we are in our conversation today.
Thank you. Dave, let's go to you. I know you have thoughts on the FTC's agenda generally.
Yeah, I think it's my view that, I think the FTC, they are looking at franchising, but I don't think they're looking at franchising because it's franchising. I think it is, you have to really connect the dots to the larger trends that are going on at the agency, and they're really, I think we're really caught in the current of a fast-moving river, and there are really three main areas that I would say that is kind of constitutes the agency's agenda. Number one, as you may know, in AMG case, not a couple of years ago, the Supreme Court took away the Commission's authority to recover financial penalties in some of their law enforcement actions. So the first main area is the Commission is trying to fill in that gap, fill in the void. And so there's now a flurry of rulemaking activity going on. There's at least 8 to 10 rulemaking proceedings in process right now. We haven't seen anything like that since the 1970s. And the second part of it is that the commissioner is trying to kind of expand the scope of the stakeholders that are taken into consideration in their policy decisions. And in particular, it's a variety of stakeholders, but in particular, workers. And it's taken into consideration in virtually every policy initiative, including mergers. And when they look at mergers now, they consider, of course, the traditionally preeminent consideration is what's the effect on consumers. But now they also expressly ask the question, what's the effect on workers? And the third area where the sort of broad interest is the Commission is actively trying to enhance its own authority. And if you haven't looked at or read about their policy statement in November about their interpretation of the antitrust side of their authority, their unfair methods of competition, they put out a new policy statement in November that departs greatly from decades of antitrust law, bedrock principles that are sort of thrown out. And it's sort of, you know, the dissenting commissioner, who's no longer on the commission, described it as a I know it when I see it standard. The non-compete clause rulemaking started 2 months later, and it's based on their new interpretation of their authority to address unfair methods of competition. And another way they've tried to enhance their authority, it came out last week, another eye-opener. It's kind of off topic, but they're reopened a consent order with Meta in a way that has never been done before. So it's kind of interesting. I mean, the commission, when they've gone down, kind of gotten out of their lane in the past, they've historically had their wings clipped by Congress or by the courts or both. That's happened to some extent in the courts so far. They've been losing merger cases in the courts, and maybe it'll happen again. But to circle it back to franchising, the connection is they're seeing a lot of things that play into their broader agendas.
For the rest of the discussion, we're going to focus really on just 3 articles of the Statement of Guiding Principles. And so the first one is Article 11, and I won't read it to you, but it basically goes to the idea that that pre-sale disclosures and providing adequate information and adequate education during the franchise sales process is really what sets up the groundwork for a healthy franchise relationship for the duration of the term. So with that article and that in mind, and as we look to the franchise rule that's under review, Karen, can you talk about what improvements to the franchise rule and the disclosure process that you see as a priority?
So I think that, you know, the consensus is that there needs to be more relevant information in the FDD to help the franchisee make an informed buying decision. So when you look at Hilton's own FDD under the rule, it's 302 pages, and that's not even my longest FDD. So we start at item 1, which discusses the corporate history of Hilton from the beginning until today globally. That takes 7 pages. Then we go to item 2, which talks about all of my franchise executives and their employment history for the past 5 years. That takes another 3. So we've opened the book with 10 pages of stuff that isn't really going to assist the franchisee in making that buying decision and is probably turning them off from going to the 11th page. So I think it's important to do a complete rationalization of the material that we have in the FDD. You know, do we think it's fit for purpose? Do we think the franchisees can understand it? Do we think that the 22 items that we have to disclose are working in the way that the drafters originally intended? Because in my own view, when I think about some of the substantive and technical matters that I need to disclose in the FDD, I think it can get in the way of telling franchisees exactly what they would want to know about buying the franchise, because it's not fitting within the 4 corners of what we're permitted to disclose in the rule. So even just simple things like navigation tools, right? Wouldn't it be helpful for the franchisee to be able to word search the document to find out what he or she wants to know, as opposed to having a chart buried in the middle of the FDD that tells you general topics you might want to know, and this is the paragraph in the franchise agreement that you would find that, and just other things such as hyperlinks or video bursts or understanding the way people communicate today. I mean, we could all get together and do a TikTok if that would help people understand what we're trying to sell. So I suggest it needs to be a lot smaller than it is today. It shouldn't be 300 pages. We need to reorganize it to tell the franchisee what they want to know. They want to know how much does it cost to get into it, what fees am I going to pay, is there an FPR, right? Because the goal here is to make sure all of our franchisees understand exactly what they're buying.
We've done a poor job of communications. Let's start there. We've talked about franchising in terms that are not realistic. We're not selling a franchise. We're licensing a mark. We're licensing intellectual property. We've created this illusion of what franchise relationship is other than what we meant in the agreement. So we're starting out in the wrong place. We have a document that was created originally in the 1960s, updated in 79, and the Federal Trade Commission grabbed it in late 70s. And all of us who've been around for a lot of years realize we haven't done much to that document. It's still 22 items in a receipt. And as Karen said, it mystifies us in many ways. I'm fairly sophisticated. I'm not a lawyer. I read slower than you guys do. But sometimes I have to read a disclosure document with 30 or more years experience and try to figure out what we're saying. All right. We all have put into these agreements everything that we feared coming off of a judicial update at the meetings. I mean, I sit there and I write it down, and my next instructions to my clients' lawyers is, hey, let's deal with that one. Back in 2007, we all got tired of having a 900-page because we had all the brokers listed. So rather than realistically dealing with the brokers, we just took them out. When they are a problem for many systems, some systems think they're captured. So now the idea in California, and I will tell you honestly from the IFA, we're looking at what is the broker disclosure document and what should be in it. This document, which is Statement of Guiding Principles, has been around since 2013. I chaired the committee that wrote this. It was vetted, really heavily. It's been through the court systems. It's been through legislation. It's a very clear understanding. You should read it. It's a very clear understanding of what franchising is from a franchisor and franchise perspective, but we've never talked about the guiding principles. We kind of put it on the back shelf. I think the solution is not to change a lot, except change a lot in the sense of communications. Franchisees deserve to have a document which they can read without having gone to some law school to read. Give me a document that you see today in business that doesn't have an executive summary. Put aside all the risk, and I know the arguments. Executive summaries are in most documents. Look at SEC documents, and you'll deal with management letters. Wouldn't we have loved to have had a management letter before COVID and after COVID to explain what was going on in the system rather than doing the gyration? We're dealing with communications. We're dealing with an honest representation of what this relationship is. And the funny thing is, Ron and I have known each other for a lot of years. And we argue often on the phone and in person. But the end game, we agree on. It's just the middle we don't agree on. And I think the answer to Ron's question is communications. How do we better communicate what we're saying? And, but leave in what those things we fear in the ABA because they're our marks and we have the right to license them any way we choose.
And I know Karen was being sort of facetious with the TikTok videos, but I think people consume information a much different way than
Absolutely.
we used to consume information. And so the idea of having, video explanations, sort of like if you're in California, you have to undergo mandatory sexual harassment training, and then, right now when you provide people with the FDD, they just sign it at the end, but how do you have any sort of assurance that folks have read it at all, and much less absorbed the information? But when you do these mandatory sexual harassment trainings, you have to acknowledge at the end of each sort of video burst that you've watched it, and then you can't just walk away, it won't continue the video or the training. And so I can see that they're being both sort of better ways of communicating in simple terms, using the FDD as more of like a reference, which is really how it's being used now, if it's being used at all, and coupling that with communicating in ways that people are just more used to consuming now, that resonate more with the folks that are going to be going into the franchise business model, which is what we want. We want people coming into the model.
It's communications on a lot of it. We're also wrapped into we're wrapped into some old thoughts around things like franchisee advisory committees or franchisee associations, and oh my God, those are bad things. They're not. They're vehicles for communications. Both sides have handled them poorly, but I will tell you that when I work with a franchisee association and it's the business people discussing issues, they can be a very highly productive force as long as they're not at the table to sue you. If they come to the table, we all get it up. But how we communicate, how we make change, how we get out in the field and understand what the hell the customer wants, and it's not just somebody not talking to the CEO because he wants something which makes no sense, which some of our clients don't make sense. We're back to this question of communications all the way up, but I think part of the tension we're facing fits into the business side of the world of how do we communicate change, how do we, not necessarily justify it. If I'm an IP holder, I'm definitely don't feel I have to justify change, but quite frankly, I need to answer the question of why, which franchisees ask. And the answer can't be because the contract says so. And often as not, a lot of the franchisors say because the contract says so. And that's a communications problem. That's what's driving our problems today.